Hey folks, welcome back to the Edupedia world, and I am Abhinay Gupta. And today again we'll continue with the chapter Audit and Auditor. So folks, in the previous lecture, if you remember, we have covered a very good and interesting topic that is about the eligibility, qualification and disqualification of the auditor. Right? That was section 141 of the Companies Act 2013. You know what, this section has already been covered, right? And I have explained it to you in quite detail. But trust me, if you go on to solve questions and answers on the same, you will be in trouble. When I say trouble is you'll be confused on a lot of portions over there. Right? So what I decided is to not leave the entire section where we did in the previous lecture, but to deal with certain case studies. Right? What will that help in? Basically is to understand each and every point or to catch the catch in the sections. Are you getting what I'm trying to say? See, basically what happens is when there are places where you involve the cash, as I said, right? When I say cash, it is company, associate company, subsidiary company, holding company, and the subsidiary of the holding company. So what are the places where these companies will also be connected? What are the other places where they are not connected? What are the places where relatives are involved? What are the places where relatives are not involved? What is the amount? What is the limit? So a lot of things will be coming in place that will confuse you, right? So in this lecture, what I'm trying to do is to make an attempt to make the entire section crystal clear with you and help you analyze the differences in all the points, right? So that whenever you get any question in the examination, you are very well equipped and you go ahead with confidence to answer it. Because once the doubt creeps in at the time of examination, you lose your confidence. And the moment you lose your confidence, it is not only this chapter or this answer, but it impacts the entire examination, right? So let us see what help I can be for this chapter to clear out all your misunderstandings or all the portions that you may not have had focus on, right? So we'll start the lecture with the cases that we'll discuss for section 141. So the first case that we take up today would be, okay, I've so written on the questions also over there. So it is Mr. A purchased goods for rupees 6 lakhs on credit for 3 months, right? So there is a 3-month credit period that Mr. A has received and 3 months being ordinary standard, right? I've written the question in very short over here just to give you an understanding of what I want to say, right? So Mr. A definitely is a chartered accountant. So we are seeing the case where the chartered accountant has purchased something from the company at arm's length price, right? At the position where the company normally gives 3 months credit period to all the customers. So they have given 3 months credit period to the auditor as well, right? And the amount of that transaction is 6 lakhs. Now what do you think will be the impact on the auditor? Will the auditor be impacted at all? Or is it an okay transaction? They can hold it. Any auditor can hold such kind of transaction. What do you feel is the question, right? So first of all, what you need to understand is about the limit. The first point that you will check. So as per section 141 subsection 3, right, of the Companies Act 2013, the limit of indebtedness, as I showed you, as I shared to you in the last lecture, was not exceeding 5 lakhs. For any amount that exceeds 5 lakh rupees, right, will result into the disqualification of the auditor. So over here, yes, the amount has increased or the amount fell beyond 5 lakh rupees, right? Second thing that you need to check is the ordinary standard, right? So in ordinary standard, yes, they have given an arm's length price and yes, they have given the credit also for 3 months, right? But what did section 141 subsection 4 say? It says that the auditor becomes disqualified. If he becomes disqualified, he has to vacate the office. So what says that he is disqualified is that he purchased goods on credit, right? And from the same company. So that is what attracts indebtedness towards the auditor, right? So understand one thing. It is not about the transaction that he has done, right? The transactions can be avoided, as you have known, as I have already shared, that if you get into a transaction that is in the ordinary course of business, it is acceptable. Remember what we said? If it is a transaction in the ordinary course of business, and this was given by the definition of business relationship. So when we understood about the business relationship, then we found out two things, that if it is a professional service which is permitted to be rendered, plus if the transaction is in the ordinary course of business at arm's length price. So this transaction is in ordinary course of business at arm's length price. So over here the auditor is okay. But what attracts the disqualification in this question is the portion of indebtedness, which is beyond 5 lakh, because even this transaction would be considered to be indebtedness because the auditor is yet liable to pay rupees 6 lakhs. So you understand what has happened and what has not happened? So this is the situation that went behind. Because when we look at it, what we see is, okay, the limit, but okay, the limit will not fall into place. Why? Because it is in the ordinary course of business and arm's length price. So we think we became a little smart and we answered it correct. But actually the crux is somewhere else, right? So these are the type of tricks that you would get. You should very much expect to get such kind of tricks in the examination, right? So next, if we look at the three partners A, B and C in firm ABC Associates. Now C, the third partner, is in the full-time employment in CD Ltd, right? And total audits held by the entire firm ABC Associates is 38. Now, there are two companies that have approached or they have proposed the audit to this firm ABC Associates, and those two companies are CD Ltd and LM Ltd, right? Now this is something that you have to get into understand from various aspects, right? So first of all, what you see is about section 141 subsection 3, the full-time employment clause. You remember about the full-time employment? Anyone of you? So it says that any person, right, shall not be eligible for appointment as an auditor if he is in full-time employment elsewhere, right? Or a person or a partner from the firm is in full-time employment. Getting the point? So if any partner is in full-time employment or if the auditor is full-time employment, they don't get to audit at all. See, it is not about that C Limited is employed in CD Limited, so he is disqualified in CD Limited. No. The point is, if Mr. C is into full-time employment anywhere around, right? So Mr. C is not qualified to be an auditor because he will not be able to do justice to anything, neither his full-time employment nor the audit. Remember we discussed this point? So that is something that will attract over here, and hence the limit of the entire firm will also change. Getting the point? Because when C as a partner is disqualified to do any audit, so C will not be considered as auditor at all. So we would say that ABC Limited has just two partners A and B who are qualified to be an auditor and who could conduct an audit. So the limit of the firm, if each partner goes up to the limit of 20, right? So the limit of this firm goes up to two partners only, that is 20 into 2, which would be 40, right? So that is where the limit also constrains. And in the question we see that they already have 38 audits. That means they can take up 2 more and they have a proposal of 2 more audits. So when you're computing the maximum, you will exclude the whole time partner, right? First thing. The next thing is C is an auditor in the firm and C is also in full-time employment with CD Limited, right? So do you think C will be allowed, or ABC Limited or ABC Associates will be allowed to do the audit of CD Limited? See, what happened over here is when somebody is in full-time employment, then that person or the firm both are disqualified. Why? Because that person, C, will have an influence on A and B. It's my firm. I am already into the company. I see the company from inside. I am on the company's side, and now the auditor comes in and I am on the auditor's side as well. So there are a lot of information that can be passed on from here and there, and that would impact the audit, right? So in that case, ABC Associates will not at all be allowed to perform the audit of CD Limited, right? But what in the case of LM Limited? So generally, if you see LM Limited case, they are allowed to take it forward. Why? Because C is disqualified, but they still have a vacancy to take in 2 clients, and LM Limited has no relation with either C or any AB. So no disqualification attracts when they go ahead with the case of LM Limited. Hence ABC Associates can go ahead and perform the audit of LM Limited but not CD Limited. Okay. Now what would be the case if the total audits that ABC Limited has is 40? We would see, okay, C's entire bandwidth is still untouched, but the answer is no. Because C is disqualified, the entire limit is 40. So if 40 is over, they would not be able to take up the audit of LM Limited as well. Next, A is auditor in ABC Limited, right, who gets in partnership with B, and B is the finance manager of ABC Limited. So in this case, what happens is that Mr. A, right, got appointed into ABC Limited, the company, as an auditor. Anytime, maybe today he got appointed. And few months down the line, maybe 6-7 months down the line, what happened is that A, that was the auditor, comes across, meets B in the company, and then they plan to get into a partnership firm. So after conducting the audit for few months, right, A decides to get into a partnership with B. Now what happens is, ideally, if B is into full-time employment, because if he's a finance manager, B is the full-time employment with ABC. So if B would have already been the partner of A would have been disqualified, right? But if we again understand, if the auditor attracts disqualification after being appointed as auditor, then in that case, the auditor will have to vacate the office, and that situation would be considered to be a casual vacancy that will be filled up by the director. So if B had already been the partner of A, then A was anyway disqualified and would never take up the position of an auditor. So the members of the company would get a chance to appoint some other auditor. But now what happened is A first took the audit and then took up the partnership and hence attracted disqualification. Now from ABC Limited, A would have to retire or would have to vacate the office, right? Because disqualification is attracted, and once A vacates the office falls under the category of casual vacancy, and that can be filled up by the board itself only, right? Now we see a little complicated case. Right? There are few things that we'll be seeing in this case. So A and B are partners in AB Associates, right? And then an appointment of AB Associate is proposed by LM Limited. But now if we see, A holds 100 shares at the rate of 10 each in LM Limited. A holds 100 shares at the rate of 10 each in OP Limited, where OP Limited is actually the subsidiary of LM Limited. So let us take the situation of both these cases, right? So what happens is, if you go back again to section 141, you know that you are not supposed to hold a security. You remember that? So what does 141(3)(d)(1) say? It says that a person shall not be eligible for appointment as an auditor of a company who or his relative or partner is holding any security of the company or its subsidiary, or the holding an associate and the entire cash. Right. So that is what section 141(3)(d)(1) says. So if I go ahead to take an audit and I am holding some security in the company, I am anyways disqualified without any limit. Right. So if in the company or the cash I am holding any security, understand my dear friends, there is no limit in securities in the same company or the cash companies. There is a limit of indebtedness, there is a limit of guarantee. For indebtedness, the limit is 5 lakhs. For guarantee, the limit is 1 lakh. But for security, there is no limit at all. Right? But yes, if you go to the next provision in the same thing, then you have the limit over there. You remember the limit of face value of 10,000 or face value of 1,000. So a person shall not be disqualified if his relative holds any security in the company of face value exceeding 1,000 or such sum as may be prescribed. And what is prescribed is something that we see in Rule 10, right? So what do you think will be the solution of this? So A and B are partners in AB Associates. Appointment is proposed by LM Limited, and A holds 100 shares of 10 each in LM Limited, that is 1,000 value. So as per 1,000, right, since he has reached the limit of 1,000, will A be disqualified? The answer is no. But no is in the case of OP Limited, because the limit does not disqualify him over here, right? But the fact that A is holding the shares in the company in which security in the company in which he is going for audit disqualifies him. So although he is saved at the limit portion, he is not saved over here, right? So A stands disqualified for the audit of LM Limited. But yes, A qualifies for the audit of OP Limited. Why? Because although A has reached the limit of 1,000 as the face value, but understand it says 1,000 or less than 1,000 or whatever amount is prescribed. And the amount prescribed as per Rule 10 is nothing more than 1 lakh. So since the limit of 1,000 is less than 1 lakh, so since the value of 1,000 is less than the limit of 1 lakh, A is allowed to go ahead with the audit of OP Limited. Getting the point? Now if we change the situation and replace A with the relative, then what? Or before that, OP Limited, now we say OP Limited is a subsidiary of LM Limited. Then what? Even then, A is disqualified to be an auditor of OP Limited. Why? Because again, if you go back to the first provision where A, the person or the person's relative or the partner holds any security in the company, holding, subsidiary, associate or the subsidiary of holding, then is disqualified. Right? So over here A holds security in LM, so LM disqualified, and A holds security in OP, and since OP is a subsidiary now, OP is disqualified. A is disqualified. If OP was an independent company, as in the first case we saw, A would be allowed, right? Now replace A with relative. So if the relative is holding 100 shares of face value 10 each in LM, is that allowed? Think. If we again go back, if they are holding any security in the cash, they are not allowed. Remember, if they're holding any security in the cash, they are not allowed. So even if A is A or A is a relative, they are always disqualified, right? But remember one thing, in case of a relative, they have again made an excuse and given a limit. That was an extension of the provision that we had read, and the limit is 1 lakh. So in case of a relative, it is not about any security, it is about security above 1 lakh. So if you read the provision along with that extension, then he is not disqualified. Right? Even though it is 1000, we read it with rule 10 and then the disqualification does not attract. So now do you understand why we deal in detail? Because as per, if you look at the provision as a layman, right? You, your relative or a partner, anybody holding any security in cash is disqualified. But if you look at the cases, again at the end, from that relative, first it says relative any security disqualified. Then it says relative can hold security up to the face value of 1000. Right? Now understand, if we take it the case of market value. Right? Now we have done basically some complicated stuff, but let me take one-liner more examples with you. Right? So let us take the case where Mr. A, who is a chartered accountant, is the director of a company. Right? Now what you have to state is whether he is disqualified to be the auditor of its holding company. Think. Because if we go back to the provisions, right? So if I am into an employment within a company, if I am an officer or employee of the company, I am disqualified. If my partner is the officer or employee of the company, I am disqualified. If it's a body corporate, it's disqualified. So a lot of disqualifications are there. Right? But if you understand, a person whose relative is a director or in full-time employment of the company as a key managerial person also, that person is disqualified. So what do you think will be the case over here? Disqualified? The answer is no. Because make sure, wherever they have said about the employment and the key managerial person, director and stuff, everything is fair, but they have always talked about the company itself. They had never spoken about the cash. The company, the holding, the subsidiary, the associate and the subsidiary of holding. They haven't spoken about that. So why do we assume? Right? So although Mr. A would be disqualified in the same company, but in the holding company, Mr. A will not stand disqualified. Trick question, right? Now next, if Mr. A is in part-time employment with the company, then can Mr. A take up an audit in that company? The answer is no. Why? Because section 143 subsection 3 only says if he is an employee, he is disqualified. Now, employee doesn't state that employee is a full-time employee or a part-time employee. Right? So even part-time employees are termed as employees, and if he is an employee, he is disqualified, no matter how much time he gives in the office. Right? So these positions, these points had not been covered in the lecture. Why? Because these were not a part of the act. But what we have to understand is this, that if they say employee over there, right, we'll have to take it into consideration that employee can be full-time and part-time, right? Next, if Mr. A is an auditor, right, and Mr. A is holding debenture in ABC Ltd, state whether Mr. A's appointment in ABC Ltd is allowed or not. The answer would be yes. Mr. A is disqualified. Why disqualified? Because it says, again the provision says that if the person, relative or anybody holds any security in the cash, right? And the security would include debentures. Debentures are security, right? So anyway, disqualified. What if the securities were held by the relative? If it was beyond the limit of 1 lakh, it would be disqualified. Below the limit of 1 lakh, it would not be disqualified. Right? So even the previous case has been rewind in your mind. Now again, Mr. A, the chartered accountant, right? Now his father was holding some share in a company, the face value of which was 15,000. But the market value has gone up to 1.5 lakhs. Now say whether Mr. A is disqualified. Now think, holding security in the company, right? For that case, all the cash are allowed, holding security in company, subsidiary, holding, associate or subsidiary of holding, anything you're disqualified. And you hold or a relative hold, and that is a relative, right? And there is a limit in the case of relative of 1 lakh. But the market value has crossed 1 lakh, it is 1.5 lakh. But what is the key to be noticed is that we check the face value and not the market value. So in that case, Mr. A would be allowed to be the partner. He is not disqualified. Right? Are you sure? Next. Again, Mr. A goes for an audit of ABC Ltd. But Mr. A's sister's husband holds shares worth rupees 1 crore in ABC Ltd. Now, will Mr. A be disqualified? Again, the answer would be no. Why? Because sister's husband, that is brother-in-law, is not included in the definition of relative. I think I did not share with you the definition of relative in the previous lecture. So, relative basically is defined in section 2 subsection 77 of the Companies Act 2013, which says relative would refer to any person, means anyone who is related to another. If they are member of a Hindu undivided family, they are husband and wife, and as it may be prescribed. And when it talks about prescription, rule 4 deals with the prescribed thing. Right? Now what is rule 4? Rule 4 says, whom does rule 4 include in definition of a relative? It includes the father, mother, son, son's wife, daughter, daughter's husband, brother and sister, but not brothers and sisters, husband or wife. But it also includes step brother and step sister. That is the definition of relative. Right? So the sister's husband is not included in relative. Right? Daughter's husband is, son's wife is, but sister's husband is not considered. Got the point? So these are some small things that we need to take care, right? Now again, A is a chartered accountant and A's sister is a CEO in ABC Ltd. State whether A is disqualified to be an auditor of a subsidiary of ABC Ltd. ABCS Ltd. Yes, the answer is Mr. A will not be disqualified. Say why? Because the relative is holding a position, not a security or indebtedness or guarantee. Remember, it is a position. And if the position is in the same company, you are disqualified. But if the position is not in the same company, you are not disqualified. Understand? The impact of cash. Cash means company, subsidiary, holding, associate and subsidiary of holding. These things come into place only when there is a guarantee or security or indebtedness, nothing else. As a person, if you are involved, these companies will not be related. As a person, only the company for which you are going will be considered. Next again, if we see, then again A is a chartered accountant, right? But he is in practice providing management service to ABC Ltd. Now you have to state whether he is disqualified to be appointed as an auditor of ABC Ltd. What would be the answer? If you refer back to any of the provisions, Mr. A would be disqualified, right? So is there any doubt over there? No, Mr. A is disqualified. It's a very short thing, right? I don't think it requires any explanation. Next, the last one that we'll take up is, again, Mr. A is a chartered accountant in practice, but he holds a derivative contract, not a debenture, but now a derivative contract. You know derivatives, right? You have studied your SFM, huh? Yes, put and sell, all those things. So Mr. David holds a derivative contract of ABC Ltd. in his own name. Now state whether he is disqualified to be appointed as an auditor. Obviously he is disqualified, right? Now what attracts disqualification is that ultimately whatever derivative or not he's holding some securities. Because if you refer to section 2 subsection 81, which is the definition of securities, right? It means over there security is defined as security contract, right? The entire security is defined under Security Contract Act. And as per that, securities includes derivatives, right? So don't be under a misconception when it comes to debentures or derivatives or anything like that. All of those are securities, and when you're not allowed to hold securities, you are not allowed to hold securities. For the case of relative, again, even in the case of derivative, the face value would not go beyond 1 lakh. If it goes, it is disqualification. Whew, so we have had a lot of discussion about the various cases in section 141, and I hope these cases have helped you, right? If you still have any query regarding anything, you can get back to me and I'll explain it in some of the classes. You post a query down, right? And then in some of the classes before completing this chapter, if your query comes in, I will tackle it in that lecture and give you the detailed answer about the same. Right? But what I consider is that, okay, lump sum, if you combine the previous and this lecture, you will get a complete understanding of section 141. Why? Because I have now discussed in detail the entire essence of the provision of the section 141, right? And then whatever could be the twist and turn, I have tried capturing all of them. Still, if there is any query, which is a reasonable query, right? If it pops up, you can write it into the comment box. But don't get into unreasonable queries, right? Because it becomes burdensome. Okay? So that will be all for the day. And I'll see you guys back in the next lecture. Until then, this is Abhinay Gupta signing off. Thank you and bye-bye.